on behalf of the Society of Certified Senior Advisors, thanks for joining us for this month's CSA webinar, The Key to Solid Power of Attorney Documents. We have a great presentation for you today. Joining us is Brad Fregon. Recognized as a Colorado super lawyer, Brad has been practicing law for over 35 years and has extensive experience in estate planning, elder law, protecting assets from long-term care costs, special needs planning, probate, and tax matters. Brad currently practices law in Colorado, Wyoming, and Kansas, is the past president of the National Academy of Elder Law Attorneys, appointed member of the Special Needs Alliance, a certified elder law attorney, a member of the Council of Advanced Practitioners, a board member of the Colorado Fund for People with Disabilities, and a fellow of the American College of Trust and Estate Counsel. In addition to his practice, Brad is an adjunct professor at Stetson University College of Law, co-editor of content for the Special Needs module of Elder Counsel, a nationally recognized speaker, author of numerous publications including co-author of Fundamentals of Special Needs Trusts, and has been quoted in the Wall Street Journal, MSN Money, Kiplinger Retirement Report, and Bloomberg. We are very excited to have you with us today, Brad. Thanks for joining us.
Well, thank you, Travis, and thank you for all of you for joining, this seminar today, and wherever you may be around the country. So, this is always a little bit more of a challenge when we can't see each other, but I hope that, like Travis mentioned, that you submit questions at the end of the program and or as we're going through this, and we'll get to some of the questions at the end of the program. And if I can't get to all of the questions, then I will answer your questions, and then Travis will send those back out in an email. So as Travis mentioned, today we're talking about, creating the solid power of attorney document. And, a lot of what I'm going to be talking about, I'll reference, I'm obviously, I'm licensed in Colorado, Kansas, and Wyoming, and I'll be referencing some in Colorado law, but, there's a lot of states have specific rules with regard to power of attorney documents, and a lot of them are very state specific about requirements as far as execution goes, what must be contained in the document. A lot of states, though, have adopted a Uniform Power of Attorney Act, and it's something that you should check out to determine if your state has enacted that act, because if it has, then it was an attempt to make power of attorney documents much more uniform throughout the country, but I don't know how many states. I think 30-some states have enacted the Uniform Power of Attorney Act, but you should determine if your state has done that. I think most of us are familiar with is this word durable power of attorney, and the word durable was required in these documents, and some states still do require that word durable in there. Is that if it did not have that term, then the power of attorney stopped when the person lost capacity, which seems counterintuitive here, but that's what that word required, and you also had to have a statement in there that this power of attorney shall not be affected by the disability of the principal. So, if you didn't have those terms, then the power of attorney would stop when the principal lost capacity, and obviously they stop when the principal passes away. So with the Uniform Power of Attorney Act, that act did away with that requirement for, putting that term durable in there. So you don't need to do that in the states that have enacted that rule here. So you have to understand, though, that what they look at doing is that because not all states have enacted that term durable power of attorney, then it's still a good idea to put that clause in there, because our clients go from state to state, and if are in a state that has enacted the Uniform Power of Attorney Act, and then they take that document and move to another state, or in that state where they have to use it, and that state hasn't enacted that the Uniform Power of Attorney Act, then the document's going to be rejected. So I still include that terms in there to make sure that whatever state that they may be trying to use this document, that I have that language in there to make sure that it does survive, continue to be effective after the loss of capacity for the principal. So how do you create, a power of attorney document? Well, it's got to be obviously in writing. We need any adult with mental capacity can create a power of attorney. We have to designate in the document who's the agent and if there are successor agents. And then we have to state and list out the powers and authorities that we are going to give the agent here. Now, when you're looking at whether a person has capacity to sign a document, and again, that would be very state specific, and that doesn't necessarily mean they have to have what we would call testamentary capacity. It could be a much lower standard about contractual capacity, meaning that, that they can have a considerable amount of mental capacity issues, but they still may not have enough sufficient contractual capacity that they understand that this document is appointing an agent to act on their behalf. Because power of attorney documents were, before we had power of attorney documents, then there was no system in place that if somebody lost capacity, we were in court getting a guardian conservator appointed for that individual. So the guardian or conservator appointed could perform acts on behalf of the person that doesn't have mental capacity. So again, it is, a very consumer-directed document that keeps us out of court if we have this power of attorney. But again, as we'll discuss, that's the good part about it, but there's a lot of bad things that this power of attorney can be used for too. And I get it a lot of times, we get, clients in situations too where, they're trying to deal with a family member or some other person, that's starting to lose capacity. And then, so they'll go out and try to get the individual to sign a power of attorney, or they actually do get the person to sign the power of attorney. And then, a week later, or the person who signed it now revokes it, and then everybody's running into court to say this person doesn't have the necessary capacity to revoke this power of attorney. But then you get yourself into the situation, well, if the person a week before, you must have thought they had capacity when you had them sign that power of attorney. Now a week later, when you're saying, oh, they shouldn't, they don't have the ability to revoke it, the agent can get in a real difficult position about that. So again, you have to be talking to these individuals and understanding that there can be a lot of problems associated with, whether this individual does have the capacity to sign this document about that. We also, too, should understand that these power of attorneys should be tailored specifically to each individual's situation. Now, there's a lot of form power of attorney documents out there. Colorado and a lot of states have what we call a statutory form, meaning that form you can, it's incorporated into our power of attorney statutes, and you can print off that form and use it. You can get a lot of online forms for that purpose. But you got to understand that those are forms, and if it doesn't have some specific language in there or limit the, language that can protect the principal, then you can get into real problems. The best example, I can give, I was just starting to practice law, and the client had signed a power of attorney document. They didn't have capacity. So I was with the agent, and we needed to get into the person's safety deposit box to check to see if the will was there and what we could, because we couldn't find the will. And, we went to the bank with the power of attorney document, and the banker looked at it. He took us to the safe deposit box, and, sure enough, the will was in there, and the agent was about to grab the will and say, to take it. And then the banker said, well, I'm sorry, under the power of attorney document, it gives you the right to look at at what's in the safety deposit box, but it doesn't give you the authority to remove any contents from the safety deposit box. So, after a rather heated discussion about that, we finally did get the will out. But I find that a lot of financial institutions, from banks or investment companies or title companies, they want very specific language in there about that. And we run into a lot of problems, like I'm sure a lot of you see too, that, you go to the local, bank, or you go to the investment company, and the investment company says, well, we don't want to accept this power of attorney document's already signed. We want you to sign our power of attorney document form, and then we will accept that form. So you'll get all of these multiple forms being signed by the client. A lot of times then that new form will revoke any prior power of attorney documents, or it will have a different agent name for that purpose. But all of those forms that those financial institutions want you to sign, they, have very specific language in there saying that, oh, you are relieving us of any liability and agree to indemnify us, the financial company, if, anything goes wrong about this power of attorney. So they always have this language in there that can, makes it where they get out of jail free because they inserted language into that document. So, we counsel clients about, yes, the power of attorney document that I have you signed is a valid document. You should not be signing other documents, and if they're requiring you to, then we might have to educate that bank or financial institution about the enforceability of this document and what their liability would be if you don't accept that power of attorney document. So, and again, whether they have liability or not would depend on your state law about that. Now, when you sign a power of attorney, it can be effective under two different circumstances. Sometimes you'll see what we call a springing power of attorney, and meaning that the power of attorney, it's been signed by the principal, but it doesn't spring into effect until the principal is determined to be incapacitated. And then they will define in the document, how that is determined, and if we need one licensed physician or two, or whatever procedure we have to follow to do that. We have another, just a standing power of attorney document that is effective as soon as the principal signs it, and there's no need to go determine if the principal, lacks capacity for the use of the document. Now, depending on who you talk to, I mean, a lot of attorneys, like the springing power of attorney document. A lot of clients think that's a much better idea because they don't like the thought of a document out there that gives somebody power and authority right away to handle their finances and do all of those acts that you've just listed under the document. Now, from my perspective, that I found that springing power of attorney documents can be more difficult to use, because what I run into is that I always have to prove that the person is, that the principal doesn't have capacity. So I get a doctor's letter saying they don't have capacity, and then 3 or 4 months later, we're trying to use the document, and then now the bank or financial company says, well, we need to see another letter saying that they still don't have capacity. So again, you can run into these problems about these springing powers, but some attorneys like them and some clients like them. And I always tell the clients that if you're concerned about your agent, and don't want to, concerned about this document being effective early because you don't want the agent having that authority, well, that means to me you're naming the wrong agent, because if you can't trust them when you do have capacity, then certainly they're not to be trusted after you lose capacity. But again, that's something that you got to talk with the client about and understand the difference and look at that document to determine whether it's a springing power of attorney or it's effective upon signing. So the most obvious, the most important thing that you're going to do with a power of attorney is, who's going to be the agent and who are we going to give authority to? Under most states' law, not all of them, but that must be an adult. In Colorado, it's over 21 years of age. Some states it's 18, but they must be an adult, and obviously should be somebody that the principal trusts. Certainly is more common to name spouses, adult children, siblings, trusted friends, but there are a lot of families out there that don't have individuals that they can trust to do that, and sometimes you have to look towards professional fiduciaries to do that, to be the agent. Now, a lot of banks don't like to serve as an agent under a financial power of attorney. There's private companies out there that do that. But again, that's something that you should be talking to the client considerably, because that's the most important decision that you're going to be making under this document. So you certainly make sure that the principal has told the agent that, hey, I've named you as my agent on the power of attorney document. You can get a copy of the power of attorney document. It's located in this place, or the original's here, but make sure the agent knows where they can access the power of attorney. The principal doesn't need to give them the document right away, but the agent needs to know where they can get the original or copy of the power of attorney. When it's needed, they can get access to it. And two, you can also put in there, very specific provisions about how we would, who has a right to monitor what the agent's doing. And does the agent have to give accountings to, other individuals? Do they have to, to exercise certain powers, such as gifting powers? Do they need to get the approval of the successor agent or some other, professional like a CPA or an attorney to allow that agent to exercise certain powers about that? Because you see a lot of situations where the agents don't understand what the responsibilities are, and we'll go through and talk about agents' responsibilities and limitations on their powers, but a lot of them, they don't understand what that is, and you can get a lot of self-dealing that agents do, and they just don't understand that they are acting in, what we call a fiduciary standard about that, and that's, what we'll be talking about here. But again, that selection of the agent is critical. Naming a successor, I see a lot of documents that, they name one agent, but there's no successor agent named. And then when that primary agent can't serve and there's no successor and the principal's lost capacity, well, that document is pretty much worthless at that point in time. So again, that is an important provision to put in. Successor agents or co-agents, whether you're going to allow them to act together or independently. A lot of people that come into my office, they have 3 or 4 kids, and they say, well, I want to name them all as co-agents because I don't want to hurt anybody's feelings, so I want to give them all authority in there. And and then I always tell them that, well, you're just picking a fight here, because that means they all have to get along, they all have to agree here. So naming a bunch of co-agents to act together can create a real problem here, and also can create a lot of liability and difficulties in administering the power of attorney document. So naming people in successive order is very, very, to me, very critical. And if you have more than 2 co-agents, it's been my experience, you're just asking for problems and asking for difficulties here. And I always say that the person that you're naming as your agent, that's the person you're not doing any favors for. They're the ones that have to do all of this. And so, when they're concerned about, oh, I'm going to hurt somebody's feelings, because they weren't named, I tell them that, well, the ones that you didn't name, they're the lucky ones, not the person that you did name. So let's look at some specific things for financial power of attorney documents. Again, I separate out, we'll talk about medical power of attorney documents for a little bit here, but I do not include, I have my financial power of attorney. I have a separate document for a medical power of attorney. You'll see a lot of documents that are combined with both of those, and certainly that's allowed to have both medical and financial contained in one document. But I've just found that it is creates problems, and a lot of times that the agent you want making medical decisions is not the same agent that you want making financial decisions about that. So I mentioned this word fiduciary, that this agent is a fiduciary to the principal. And a fiduciary, it could be an agent of a power of attorney, a trustee of a trust, personal representative of an estate. Those are people in fiduciary arrangement with the principal. And when you're a fiduciary, you have these specific standards of care that you have to follow. And if you don't follow those standards of care, then you have liability for what you're doing over there. So you're supposed to be acting as what we call, the substitute judgment on behalf of the principal, and acting in accordance with their wishes. But as we'll talk about too, that sometimes the wishes of the principal are wishes that just can get the agent in trouble, because they may have some very unrealistic directions about, how their investments should be handled or what they should be investing in, or they have some very, unrealistic decisions about, selling property or keeping property or making financial transactions. So the agent understanding, what the responsibility and liability are is very important. And if there are limitations that the principal wants, or specific directions, that should be drafted into the document. So, but a lot of agents do not understand what their duties and responsibilities are. We include, and under the Uniform Power of Attorney Act, they have provisions that we include at the end of the document that sets out the agent's obligations to act as a fiduciary for the principal. So that we require the agent at the time they're going to utilize the document that they have to sign saying that they've read these and I understand what my responsibilities are. So too, the other problem which I talked about briefly too is just, you sign the power of attorney, you've got the agent, they're all in place, and then there's a lot of times, we continually run into problems with, banks, financial institutions, title companies, you name it, rejecting the power of attorney document because they don't like something because it was signed 5 years ago, or, they don't like some of the language about that. So you have to understand and talk to the attorney about, does the state have an enforcement statute that this third party who's refusing to accept the power of attorney, do they have liability for that refusal? So it's just kind of the name of the game anymore that when you're going to a bank, a credit union, the teller, they just started 2 weeks ago and they don't know a power of attorney from anything, and then, they say, oh, well, I can't take this, or, it has to be this way because it doesn't fit on our form. So it can be frustrating for a lot of clients when these things are rejected, and sometimes it does take, a letter or a call from the lawyer to remind them of their liability for not accepting the power of attorney document. So again, agents' responsibilities to the principal, and I apologize in here. We have a thing, called, I have the prudent man rule. It actually should be the prudent person rule. And again, when you're talking about this rule, you have to look at your state law to determine whether you have a prudent person rule. And again, that means that the agent must be exercising due care and manage the principal funds, not as if it were the agent's money, but it's the principal's money, and you have to exercise due care in doing that. Now, that doesn't mean necessarily that you go take the money and you invest it, leave it in a money market account or some savings account that's earning 0.001 of interest. It doesn't mean having it in a conservative investment relieves you of liability. It just means that if there's assets that do need investing, that the agent should be getting advice from a professional about how they should be invested and what the appropriate role is, investment mix would be for under this situation. It certainly doesn't mean that the agent should be, continuing with, high-risk investments or something that maybe the principal was in that is a very high risk, because again, it's not the agent's money and it's the principal's money, and you're in a fiduciary standard with that principal and have to act according with that. So, under the Uniform Power of Attorney Act, then, they have specific provisions in there that are requirements that says what the agent's responsibility is. And again, you'd have to look at your state law to determine, if that Uniform Power of Attorney Act has been enacted in your state. So act in accordance with the principal's reasonable expectations to the extent known to the agent, and otherwise in the principal's best interest. Sometimes the principal doesn't know what there's in their best interest, and they've been doing some pretty crazy stuff. So again, the agent doesn't mean you continue to follow that act. It's just that, but you need to have some idea about what the principal wants to get in accomplished here. They need to act in good faith, act only within the scope of authority granted in the power of attorney. That means, the agent needs to read the power of attorney, see what authority they have under the document, and then only act, in accordance with the authority granted here. Act loyally for the principal benefit. And also, which can be very difficult with family members, is to avoid conflicts of interest that impairs the agent's ability to act impartially. I get a lot of agents, and we see this all the time, where, the agent says, well, the principal, they've got a bunch of money sitting in this money market account that's earning, very little interest, and maybe what I can do is I can borrow some money and pay off my home loan, and I'll pay the principal a little bit higher interest rate here, and set this up, as secured by my home on a 30-year mortgage. And the agent thinks, well, I'm, just trying to get them a better rate of return. Or, I've got the agent saying, I've got this company I'm starting, and I'll give them some stock or membership interest under here if if they'll just put some money as an investment into my company here. And it's a great investment, and it's going to be earning a lot more than if they just leave the money in the bank. And we see that all the time where the agent's doing self-dealing, or providing loans to family members and things of that nature, and and that's a breach of fiduciary duty. And even though they may be paying a higher interest rate, maybe they are, it is a good company, but most of the time it's just to the detriment of the principal, and gets everybody in trouble here. Other agents' duties and responsibilities, and as I said, we have this attached to our power of attorney document, so the agent is signing off on that. Act with care and competence and diligence, ordinarily exercised by agents in similar circumstances. So if you have a specific knowledge or degree in finances, well, you're going to be held to a higher standard of care with regard to the principal's money. The biggest issue we have is, people don't keep records of what they've done, and so they cannot produce an accounting. And what happens all the time is, the agent needs to know what they started with and know what they end up with, because what happens after the principal dies, then the heirs of the estate, the other whoever that may be, come back and say to the agent, well, we think you took money or did this, 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 and this, so we want you to provide an accounting. And then the agent's going, well, I don't have any of these records, or I didn't keep track of anything. And then there's a real, a problem associated with this. A lot of times too, that family members, they just don't, they just kind of gradually take over. They don't take over at one certain date. They start helping out mom or dad, and then they gradually assume more and more duties. But again, that is not being able to account for what you've done can create a huge problem. So, and I see this all the time where after the principal dies, then the other heirs are coming back and saying, we think something's missing here, so we want you to account for the last, however many years you were acting as agent, and show us what you did with this money. So the other thing too is the agent shouldn't be upsetting the principal's estate plan. So if they have a will or trust in place, they need to make sure that they're not doing anything contrary to what that estate plan is saying. So that could be, who they're making gifts to, if they're changing any title to assets and things of that nature. It's important that the agent understand what the principal's estate plan is here. A new thing that started that we include in all of our power of attorney documents too, there's a Uniform Fiduciary Access to Digital Asset Act, and that's a very new act that was only been passed in the last 6 or 8 months, I believe. And again, not all states have enacted that. But, it didn't used to be an issue with regard to people's Facebook page, their, digital assets that they have, and who has authority, whether the agent has the authority to access that and to delete things or preserve things or anything like that. So Colorado has enacted that, so we put specific powers and authority in our document with regard to those type of assets to make sure that the agent would have authority to do that. Now, the bigger issue too gets into, do they have the passwords and can we access that? But, if you don't have passwords, then you're trying to access the Facebook page or whatever digital assets they have, then you have to contact the company and show that, oh, this person's lost capacity, I'm the agent, here's the specific authority that I have in this document showing that I have authority to access this account. Again, if the agent knows where the passwords are, that makes it a lot easier, but keeping passwords and things of that nature, there's some products out there that allow people to have a central location for all of these passwords and talking to people about having those products so people can access those passwords, whether it's for virtual assets, bank accounts, or whatever, can be very, very important about that. We talked about too is the authority of the agent, and the authority is it needs to be specifically spelled out into in the document. And there's general authority, but you have to really be talking to these agents about whether they want other ability to create, amend, revoke, or terminate an inter vivos trust. Under no state law do I know of where an agent can create a will for a principal. But some state laws do allow an agent to amend a trust. Whether you want to give gifting authority under that document, whether the agent has the authority to make gifts to themselves. And that's an important provision about that. And again, whether that is you want to give that agent of authority, you want to make sure that that gifting authority follows the individual's estate plan, and maybe you want somebody to sign off, another agent or some other third party to sign off to make sure that the gifts, do follow the estate plan, because there can be a lot of reasons, whether that's for tax planning, it could be qualifying somebody for Medicaid services. But you want to have a discussion about that gifting authority in there, because that can work two different ways. You can have where there's no gifting authority, but the agent's off there making gifts of the principal's assets, and then they run across a state law like in Colorado and most states now, where there's some type of elder abuse statute. And if there's no authority under the power of attorney to make gifts, and make transfers into the agent's name, well, the agent may have just completed a criminal act because they made a transfer of the principal's assets, who is, an elder or a disabled individual, and without any authority. And that can be a criminal act under a lot of those elder abuse statutes. So again, having that type of information in there is very important, and having these specific powers in there, disclaimers, gifting authorities. You also generally want the ability of the agent to delegate authority, because the agent could temporarily not be able to act, and then you want them to be able to delegate authority to another individual to do something, and that comes up all the time in power of attorney documents where the agent's just not available, or they need to delegate authority because they're going out of the country or whatever the situation is. Certainly, we talked about misuse. I talked about conflicts of interest, breach of fiduciary duty. Again, we see that happening all the time. Whether, in the document, is the agent entitled to compensation or not? How is that compensation determined? So again, all of these things need to be spelled out in this document to make sure that you avoid problems down the road about that. So again, they can, they have civil liability for breach of fiduciary duty. They could have criminal liability for under your state law, elder abuse statute, if there's no authority to transfer assets, gift assets, or gift them to themselves, and they're out there, transferring assets here and there, they may have some criminal liability for doing that. So again, all of that is important information, that need to contain, and that's why the principal needs to sit down and, talk with a lawyer. If they need to, always having one of those, whether it's they printed out a form. Generally speaking, I'd rather have, some document signed than going into court. But again, it's, people like you all know, a lot of times they don't get motivated until there's some type of crisis going on. But once somebody's starting to lose capacity, it just makes it so much more difficult to get these documents signed and get them into place. And that's why, when you can encourage people to get in to see their lawyer, make sure these documents are updated, it is just really of critical importance here. I want to talk briefly just about medical power of attorney documents, and again, these are very statutory, state-specific about that. I separate these power of attorneys, so I have a separate medical power of attorney and a separate financial power of attorney. But we also put a provision in there, if I have different agents that are acting under the medical and financial power of attorney, how those agents are supposed to be interfacing with each other, because we may have a medical agent under power of attorney saying, I want the principal to go, into this facility or to have in-home care for this, but then the agent in the financial power of attorney refuses to pay for it. Or you may have a provision where the agent of the medical power of attorney is ordering all of this care and services, but the principal doesn't have that much money, so the agent, correctly so, is going, look, they can't afford this. So we put provisions in our documents about, who has authority to make these decisions, what happens if there's a dispute between the agents, and write that out in the document. So when we get into that situation, we have a procedure to handle it when they're not getting along here. The most important thing about the medical power of attorney is having in the document, so where we have this HIPAA release, so the agent can actually access the medical records. If that HIPAA provision is not in the document, it may be a separate document. Then the agent has no authority to access that information or talk to the person's healthcare providers. And a lot of these older medical power of attorney documents that you see don't have that authority in there about that. Interstate effects, certainly like a financial power of attorney, a medical power of attorney, if they go across state lines, they're still a valid document. So, a document I draw up in Colorado, if they take it to Kansas, is still a valid document. But again, because these rules are very state-specific, if somebody is moving, I always tell them you should get a state-specific medical power of attorney, financial power of attorney, because these are, again, lifetime documents and documents that you need to make sure that are appropriately drafted for that. And a lot of states have different types of, do they need to be witnessed? Do they need to be notarized, or both? Under the gifting authorities, does that need to be witnessed? So each state has a lot of different requirements as far as how that document is executed. And again, that's why you don't want to risk getting these documents rejected. So having a state-specific one is always better. But just because they went into a different state, if it was a valid document in Colorado, Kansas is, is going to recognize the document. So they do cross state lines about that. A lot of people get confused with living wills and medical power of attorneys. You can have them combined into one document, or they can be separate documents. Living wills are basically controlling end-of-life decisions and things of that nature. So again, you have to consult with your state statute, state rules with regard to that to determine whether they should be combined into one document. Under Colorado law, a living will is just controlling end-of-life decisions. And I can put power of attorney provisions in there, but it's just controlling end-of-life. If I do not do a living will, then my agent has the authority to make end-of-life decisions for me, whatever that may be. So again, you need to be consulting with your own attorney in that state about, what documents are you required to have about that. People get confused about DNR orders, do not resuscitate. A living will, if I have a living will, I can have it stapled to my chest, but if what someone calls 911, they're going to come and they're going to resuscitate me. And they don't care what my living will says. A DNR is a doctor order, and that I either have to have a bracelet on that says that, or if I'm in the hospital, that there's an order attached next to my bed saying do not resuscitate. But that is a doctor-ordered requirement. Some states have separate forms for the disposition of last remains that can be in the medical power of attorney document also. But again, that's something important for people to be talking about and things of that nature. Now, I have a few more minutes here, and I have this section done for an interactive session, but I can't really interact with you. So I'm going to go pose the question and then, tell you what the issues are about that, and so that's about as interactive as I can get here under this circumstances. So you are named as the primary agent under your mother's power of attorney. Mom's primary bank account is owned by her and your brother, and you don't get along with the brother. You want to start paying bills from the account as a POA, but the bank refuses to let you. Well, they're going to refuse to let you because the brother is named as part owner. And I see that a lot too, where people think, oh, I've got to go put my kids' names on these accounts so they have authority to write checks. and they're made an owner of these accounts, and then they check the joint tenancy box of that. So when the person dies, that one child then ends up with that entire account because they were listed as an owner. Well, they're not to be listed as an owner. If you have the power of attorney, you take the power of attorney document in, take it to the bank, the credit union, you give them the document, the agent signs a signature document card, and to make sure that they're, have signature authority, but they're not to be listed as an owner about that. The other issue that I always lecture people out there is, when the agent is signing, you're trying to check your mom or dad or somebody into a nursing home or hospital, and they're having you sign all of these documents, admission documents, we'll always make sure that if you're utilizing this or you're telling the agent, that the agent, they're just signing their names and they don't realize that, oh my gosh, I just signed this personal responsibility provision. So if they can't get the principal to sign their name, then the agent needs to make sure that they're signing, and disclosing this agency relationship. They're signing the principal's names by their name as power of attorney under the document dated such and such date here. So that's important that clients understand that. Here's another thing that I see all the time is mom has 3 kids. She owns a house and 3 CDs worth $50,000. Mom signs a POA naming you as her primary agent, but each of the CD is listed has a payable on death to each kid. So each kid has, 1 CD because mom thinks that's a great idea. I'm going to treat them all equally. Well, mom goes into a nursing home, and now you need to access money to pay her bills. So which CD do you take? Well, obviously, if you start taking your sibling CD and using that money to pay her bills, but your own CD that you've got that's going to list you as the payable on death beneficiary isn't touched, you're going to generate a fight with your siblings about why did you use my money instead of your money for paying all of these bills. But again, I see that all the time, and that's why having these payable on death accounts like that can run into a lot of problems here. Probably one of the most difficult situations we see people get into is, you're starting, your parent has a client has a serious stroke, but prior to that stroke, she told you, she's got all of these stocks and she's had them forever, and whatever you do, don't sell these stocks, just keep them. Well, she loses capacity because of a stroke, and then all of a sudden the market's crashing later on. And of course, since she just had her investments in just a couple of assets, it loses all of this money here. So again, well, the agent was trying to follow her directions, but unless those directions were documented in, a letter, it was documented in the power of attorney, the agent may have some liability there. And so, because they weren't acting as a prudent person and diversifying or, trying to minimize any loss about that. So again, or where agents start doing some things, they start paying bills, but they don't talk to the investment advisor. Or you have multiple agents and one agent's out there doing everything, the other agent's out there doing nothing. Well, the agent that's doing nothing, they still have the same liability as the agents out there doing the actual work, and they can't just turn their head and say, well, I didn't know, but they all have liability about that. So again, those are, what we counsel the agents about, and that's why I tell all of these agents that, hey, look, your parents didn't do you any favor, or this client didn't do you any favor because they put you in this position. But if you follow these instructions, you'll be okay. And as I said, every client should have a power of attorney document, and because that keeps us out of court. But not everybody does it, obviously, and these documents can be used for a lot of good purposes, but they can also be used for bad purposes. And that's part of what you all will be seeing when they're being used for bad purposes, and what's your obligation to report, and what what responsibilities do you have? So I'm going to turn it back to Travis here so I can have a couple minutes to answer any questions that you all have submitted. And then, as I said, for any other questions we don't have time for, I'll write those answers out. So make sure you don't give me a long, difficult questions here so I can keep my answers short. So, Travis?
Absolutely. Thank you, Brad. I will do my best. I would say that a majority of the questions regarding the power of attorney are fairly difficult questions, so I will do my best here to keep things moving. So let's see. The first question that I have is it required that an attorney draw up a durable power of attorney?
It's not required that an attorney draw up a power of attorney. As I said, you can print out these forms online, and people can sign it. It's just like people can print out a will and sign it without an attorney. But you should not be, if you're helping somebody, where you are preparing the power of attorney or giving it to somebody and helping them fill it out and taking a fee for that, if you did something wrong, you may have to create liability for yourself. But, clients can go fill out these forms if they want, but people don't understand the document. So that's what, as I said, from my standpoint, is the document is me explaining these rules and explaining what we should put into there, and drafting it specifically is, why I'm involved here. But people are free to print off and sign whatever they want to here. See it all the time.
Okay. And the next question, can an agent charge a fee for his services during the principal's lifetime and after passing when acting also as a trustee and fiduciary?
Well, the first thing you would need to look in the document is to determine if the document gives you authority to charge, a fee, because some documents specific will have a provision that says my agent can't charge. So, the question is then whether the document gives you that authority. Now, if it does give you authority, then the question is how much you should be charging and what's reasonable. And some states have specific rules to determine that. Colorado, most states, to say you're entitled to reasonable compensation. So what would somebody else, if you had to hire somebody to go do these services, what would they charge? You cleaning out a garage and charging $100 per hour to clean out the garage versus you doing, doing complex financial or handling business relations for them and charging $100 per hour, you shouldn't be maybe charging a flat fee for everything. And a lot of courts will look at that if you had to go drive the person around and you're charging $100 an hour for that. That can create problems for you. You have to understand that a power of attorney document stops when the agent has notice of the principal's death. So your authority under there stops. And so any acts or anything that you're doing afterwards would, you can't charge for because your authority is stopped. If you're named as trustee under a revocable trust, and that revocable trust is, that trust doesn't terminate at the principal's death, so, you could still be charging under that.
Okay, thank you. The next question is, would you recommend not serving as a power of attorney when there is family conflict? And the question goes on to state that this person has been asked to serve as a neutral third-party power of attorney, but is hesitant because of the sibling conflicts. Do you have any advice in that regard?
Well, the person's, instincts are pretty good there when there's the sibling, conflicts about that, and you're caught in the middle of those things, then, that can get very nasty. You always have to remember, too, that, if you lose I always say whoever has the checkbook wins here. So if you're serving as agent, you resign, they come back later on and sue you, well, how are now you don't have money to defend yourself. You should look at whether under your insurance, whether you have any coverage for for these types of lawsuit if you are in that position for doing that. But again, I would look at is there a professional available for that? I rarely serve as agent for clients, unless they just don't have any family members because of that situation. And so I try to stay out of that. You should network with, there's private fiduciaries out there, and you should network with them and see what they would do, and or talk to your local banks about that to see if they will serve and under what circumstances. So you have some other referral sources for those exact cases. And I always say that in those situations, no good deed goes unpunished, and that can happen a lot when you have a family that's dysfunctional and fighting.
Absolutely. Let me get through a couple more questions here. The next question is, I realize that a client should have capacity to cancel a will or power of attorney. However, if they rip it up, doesn't capacity no longer matter?
Well, it still would matter. I mean, it's a good question. It's a great question, and again, you have, if somebody rips up a power of attorney document and there's no other document about that, then that's obviously a revocation of the document. But the question is, did they inform the agent? Did they inform these other institutions that are dealing with the agents that this has been revoked? But again, it can be a person's capacity, and somebody's torn up a will, but they don't have capacity to do that. But those get to be very difficult questions, and as far as what was going on with that person at the time that they tore that up. But after the fact, it's usually it's going to be presumed that they intended to revoke it. So, but again, the fact that they tore up the power of attorney, and if the agent didn't have notice of that, well, the agent can still be out there operating with a copy. Or if the bank doesn't know they tore it up, and the bank's still dealing with the agent. So it's important to notify that agent that it has been revoked. But again, those are situations that's very what's going on with that person at that specific time. So
Right.
Great questions.
This will be the final question. I understand the difference between a financial power of attorney and a healthcare power of attorney. Is the term durable power of attorney an umbrella term that covers both, or can it refer to one or the other of financial versus healthcare?
Well, again, the word durable is I put them in both documents about that. The Uniform Power of Attorney Act did away with the need to put durable in your financial. The Uniform Power of Attorney Act doesn't deal with medical directives at all. So I put that in there, and again, because people go from state to state, I want that term in there because not every state has adopted that act. So.
Thank you, Brad, so much for covering this. It's definitely very interesting, and it was very high demand. So thanks, everyone.
And thank you, Travis, and thanks for everybody for attending today.
Perfect. And before everyone leaves, I would like to just take a moment to remind everyone, please feel free to send any questions, comments, suggestions, or concerns to myself. That's travisr@csa.us. And please join us again next month for the CSA Monthly webinar. On July 20th, we will be joined by Tom Breedlove from care.com, and we will be discussing when families choose to privately employ caregivers, what advisors need to know. The registration is open also on the website, and we hope you will join us. And again, all of these webinars are brought to you by the Society of Certified Senior Advisors. Please join us every month for an exploration of different topics, tools, and techniques related to aging. Thank you so much, everyone. I hope you enjoyed it, and I hope you will join us again next time.